I found this story on a website called the Marijuana Moment.
What part of
Which, you know,
Google were you on?
I know I'm frequently on marijuanamoment.com. I mean, that's, you know, it's really my homepage. But they did the best job covering this guy named Ben Adlin, who, by the way, if you look at his picture, he doesn't look like a dude that would write for Marijuana Moment.
I'm gonna go follow that link and
Don't you think?
take
I
a
don't
look.
know. Maybe he does. Maybe he looks a little marijuana-y. Anyway, they did a really good job talking about this story. So a federal judge in Texas rules that ban on gun ownership by marijuana users is unconstitutional as applied.
It's like Andrew's cousin,
Andrew who?
Andrew Hayes.
Yeah, he kind of, I guess he kind of. Well, so Andrew's a very professional guy. That's what I'm saying. Like this guy
Right,
doesn't
he looks like a.
He doesn't look like a Marijuana Moment,
right.
journalist.
You're right. He doesn't.
So a federal judge in El Paso has ruled that U.S. government's ongoing ban on gun ownership by habitual marijuana users is unconstitutional in the case of a defendant who earlier pleaded guilty to the criminal charge. I feel like you should add dude like every couple of, you know. Mm-hmm. The court this week, allowed the man, to withdraw. No, I'm not going to do that. So the court this week allowed the man to withdraw the plea and ordered that the indictment against him be dismissed. Now, this is something we've talked about for a while. And I've brought up the fact that, so marijuana use in California is legal according to state law. It's still a controlled substance, although they rescheduled it recently, but it's still a controlled substance federally, which means that there's a conflict between the state of California and federal government. Federal government says if you're using marijuana, you're a prohibited person. In fact, it's really almost to the point, the way the law is written, and I'm exaggerating here, but it's almost to the point where if you have any record of ever using marijuana, especially if you have like a medical marijuana card or something like that, then you're pretty much you're kind of prohibited for life. You know, it's really a very pretty vicious piece of legislation. Firearms Policy Coalition this is one of their cases. A Texas federal judge ruled today that the federal ban on gun plus drug possession is unconstitutional as applied to a defendant who was not shown to be, quote, intoxicated by marijuana at the time of the incident or at the time he was arrested, end quote. So basically, you know, if you drink alcohol, you know, you can still be a gun owner, but if you're drunk and using a firearm, that's a problem, right? So this person was a marijuana user, apparently, but wasn't using marijuana at the time of that he used his firearm. So from the decision, the history and tradition before us support at most a ban on carrying firearms while an individual is presently under the influence. Here, while the government goes to great lengths to disclose the defendant, quote, admitted being a daily user of marijuana since age 14. First off, why would you admit that?
Right.
Why would you say that?
Well, from using it since he was 14, it might have damaged part of his brain.
And that defendant, quote, just liked good weed. It's the just liked good weed defense. I mean, look, buddy, what's your problem, man? I just like good weed, man. All right, it does nothing in the way of proving the defendant was intoxicated by marijuana at the time of this incident or at the time he was arrested. In line with the Fifth Circuit's reasoning in Connolly, this court agrees that, quote, based on habitual or occasional drug use, imposes a far greater burden on the defendant's Second Amendment rights than our history and tradition of firearms regulation can support. In conclusion, the defendant is part of, quote, the people, and the people are the ones that have the right to keep and bear arms. The defendant is a part of the people whose conduct is covered and protected by the Second Amendment. Because he is part of the people, the government had the burden to identify historical analogs similar enough to show that individuals like the defendant were disarmed at the time of the founding. So at the time of the founding, let's say 1791, were they finding people who were smoking pot and taking their guns away? Were they finding people that were intoxicated anyway and were taking their guns away? No, there's absolutely no evidence of that at all, which means that it is unconstitutional according to, the Bruin decision. Now, the cool thing is, I got to tell you, man, FPC doesn't mess around. And I love them for that. This problem should have been solved, and it's not completely solved yet, but this is a step in the right direction. This problem should have been solved a long time ago. But the problem is Democrats hate guns and Republicans hate pot. So neither one of them wanted to touch this. They're not, remember, they don't get voted into Congress because they're trying to help you. So it just sat there and people were affected by it. Now, California, it was kind of ignored, for a while, but that's not the solution to a bad law. So in response to the challenge to the firearm restrictions constitutionality, the Department of Justice lawyers argued that the defendant wasn't part of the people referred to in the Second Amendment because illegal drug users are addicts. Illegal drug users and addicts are by definition not law-abiding citizens covered by the amendment's text. I don't remember seeing law-abiding citizens in the Second Amendment.
Right.
That's not in the text.
Correct.
But the court disagreed, noting that Daniel's opinion points to 5 mentions of the people in the Bill of Rights and says that in each place it refers to all members of our political community, not a special group of upright citizens. The other thing is he was not law-abiding because he was breaking an unconstitutional law. You know what I mean? Like, that's not...
It's a circular argument.
Yeah, right? I mean, you can't... he's not a good person because he was breaking the law. Oh, by the way, the law is completely unconstitutional, but he was breaking it. You can't judge a person's character by that. You might be able to judge their intelligence or their aversion or, to risk, but that was such a cop-out. That was such a weak argument. The defendant is part of the people whose conduct is covered and protected by the Second Amendment, the ruling concludes. Because he is part of the people, the government had the burden to identify a historical analog similar, et cetera, et cetera. We just read that. One issue that emphasized that the judge emphasized in his ruling is the lack of evidence that the defendant was actually under the influence of marijuana. Might have been a different case if this guy was, clearly, high or,
All they had was his admission that he was a user.
A daily user since 14. I wonder why. I'd like to. I didn't see.
Well, you know what commonly happens is people when they feel that they've done nothing wrong, they tend to kind of vomit information.
Yeah. Don't ever do that, guys. Yeah. Don't ever do that. You have the right to remain silent.
Exercise it.
Exercise it. The marijuana moment went on to say that that brief was the latest response to a case filed by a Pennsylvania prosecutor suing the federal government over its ban on gun ownership by cannabis users. You know it's a marijuana moment when they we refer to it as cannabis. You know what I mean? It's not pot. It's not wacky tobacco. It's cannabis. It came 2 weeks after lawyers for the official Warren County District Attorney Robert Greene asked the U.S. District Court for the Western District of Pennsylvania to allow the matter to proceed to trial. I hope, and it goes on, it's a good article. They actually did a really good job. I'm making fun because I think the stereotypical pot user is fun to make fun of. I'm not a pot guy. I've never used pot. I grew up in Florida, Hawaii, and California, and those are, that's their major cash crop. Right. Is pot in those 3 states. There's a lot of pot users in those 3 states. And I just never was interested. I was never really against it. It just wasn't interesting to me. And frankly, a lot of the pot users I knew were kind of silly. They were kind of ridiculous people. Yeah. So you ended up blaming it on the pot. I don't know. I don't think pot's any more dangerous than alcohol. In fact, I would argue that alcohol, is probably a lot more dangerous than pot. Although, alcohol is legal and you're not a prohibited person if you drink every now and then or drink every day. So I hope this problem gets solved. And the reason I hope it gets solved is not because I'm some fan of pot, but because the Second Amendment is not a secondary right. It's important. We need to assert ourselves in every way possible. So I hope it goes on to win. Hey, everybody. Thanks for watching. I'm Michael from Gun Owners Radio. If you liked what you saw, please don't forget to like, subscribe, share, and make a comment. Help us out. Go to gunownersradio.com. Thanks for watching.